Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to lecture number 9 of our course on law of copyright, patent, trademark and other IP. In last few sessions we discussed about copyright law. As I mentioned, with this session, lecture number 9, we will start our discussion on patent law. We'll devote 5-6 hours on patent law and then we'll talk about trademarks. I have given the introduction of patent law in my first lecture. I said the subject matter of patent law is invention, and the key word I mentioned then is novelty. Your invention has to be new. Let us understand what is a patent and what are the criteria for obtaining patent. Patent is a limited monopoly. As I mentioned about copyright, these rights are not unlimited rights. These are limited over time. And patent is a limited monopoly which is granted to the inventor, and in return the inventor has to disclose his invention to the patent office. And in copyright, I mentioned once that the duration of protection for literary work, for example, is lifetime of the author plus 60 years. So it's a very long duration of protection in copyright, whereas in patent law the duration of protection is just 20 years from the date of filing of application. Now we can see the duration is very small, but the rights in patent are very extensive. And how do we decide duration? Mainly on the basis of the nature of rights. If the rights are extensive, a small duration will be sufficient for the inventor to recoup his investment and earn some profit. Now when it all started, initially it used to be a very crude document, very simple document. Nowadays, if you look into granted patents or patent applications, these are highly sophisticated, complex and lengthy documents. So therefore, we are now going to study a document, we are now going to study a subject which involves science, technology, and the purpose of patent law is to convert science and technology into something commerce. Invention is the subject matter, as I have already mentioned. There are two types of patents. This is based on subject matter classification. The first is product patent, where the inventor is granted monopoly on the product per se. And when he is granted monopoly on the product per se, his monopoly extends to all the uses of that product also. No matter how you prepare that product, the product will be owned by, the patent on the product will be owned by the inventor. But at times, if the product is already known, you only have the option to claim monopoly on the process, on a new process to make that product. So that is how we can classify patent on the basis of subject matter classification. One is called product patent, where the product per se is granted monopoly, and second is process patent. I said subject matter of this subject is, subject matter of Patent Act 1970 is invention. Section 2(1) defines invention, 2(1)(j). It says invention is a new product or process involving an inventive step and capable of industrial application. This is not exactly a definition, it is more in the form of factors or criteria to get patent. Invention is any new product or process involving an inventive step and capable of industrial application. So there are three factors which you can see in the definition. One, it is new, any product or process, it has to be new, it has to have inventive step, and it has to have industrial applicability. We will talk about these criteria in this session. But keep in mind that when we are saying, using the word invention, we do not necessarily mean that invention has to be a complicated thing. No, a very simple invention can also be granted patent. But the requirement is there must be something more than mere carrying forward of a known principle. So, therefore, if I summarize, in order to get patent, the invention in question has to pass the requirements of novelty, inventive step, industrial applicability, and it must consist of subject matter that is patentable. So, there are 4 factors which I mentioned. It has to be new, it must have inventive step, it must have industrial applicability, and it must consist of subject matter that is patentable. Out of these 4, we will discuss first 3 in this session, and we will take up the last point in our next lecture. So, let us start with the criteria to obtain patent. We have understood that patent is a limited monopoly which is granted to the inventor. In return, the inventor has agreed to disclose his invention to the patent office. So, therefore, it is a kind of agreement between patent office and the inventor, where the consideration is monopoly and disclosure. We also understand that there are 2 kinds of patents. One is product patent, the other is process patent, and the subject matter which we will be talking about in Patent Act 1970 is invention. Invention has been defined in 21J. Now, let us see what these factors mean. The first criteria to claim patent is novelty. The invention has to be new. And when can we say that invention is new? An invention is said to be new if it does not form part of the state of the art or prior art. Prior art has to be defined first of all. Prior art is defined in a very broad manner to include all matter that is available anywhere in the world before the priority date of an invention. And priority date can be defined as the date of filing of the application. Now, all these things have to be understood together. An invention is new if it is not anticipated in prior art. An invention is new if it is not to be found in the prior art. A prior art is any information, any matter which is made available anywhere in the world on the date of filing of application. So, therefore, an invention is new if it is not anticipated in the entire knowledge pool, if it is not to be found in the entire knowledge pool which existed on the date when I filed my application for getting patent. So, what I am doing is I have to compare my invention with the entire knowledge pool, entire matter, entire information which is available on the date of filing of my application. So, priority date, which is the date of filing of application, is the date on which we will be examining novelty, inventive step, etc. This is the date on which the entire knowledge which existed will be used to find whether the invention is new, whether the invention has inventive step or not. In determining novelty, we are comparing the invention with prior art. So, novelty is qualitative difference between the invention and everything which exists in prior art. There are few important observations. Why do we insist on novelty? We insist on novelty as a criteria for granting patent because that ensures that information from prior art, information which is there in public domain, is not granted monopoly to somebody. Nobody can claim patent on information which is already available in public domain, and that is how those who have been working, those who have been practicing, those who have been using that knowledge are allowed to use it and are not stopped because of some patent coming in their way. So, it supports right to work arguments. Nobody can be granted patent on something which is already there in prior art. But when we will define prior art, we will see that prior art is very broad. It is very extensive, entire knowledge anywhere in the world. So, that gives an impression that definition of prior art is so broad that at times it will be difficult for the inventor to prove that his invention is new. It may produce harsh results. So, we will understand about these observations. But novelty means that the invention is not to be anticipated in the prior art, and prior art means the entire knowledge pool which exists on the date of priority, and date of priority means the date of filing of application. Let us understand more this concept, state of art or prior art. Prior art, as I said, is defined in a very broad manner. It is defined in inclusive terms. As I mentioned, all matter which is available on priority date, all matter which is made available to the public on the date of priority shall constitute prior art. How that information came to public domain is not relevant. It can come by oral descriptions, it can come by written descriptions, it can come by use. There are many ways through which an information can come to prior art. I said any information anywhere in the world means there is no geographical limit. So when I am examining novelty of my invention, I will compare the invention with every information available anywhere in the world. There is no geographical limit. I said there is no restriction on mode of disclosure, how the information came to prior art. It can come by way of written description, prior use, exhibitions, sale, oral communication. Somebody must have communicated about it some 100 years ago. It has come to public knowledge. So all this information is part of prior art. All this information will be used to see whether your invention is new or not. Age of the information, obscurity of the information, duration, language, location, all these are irrelevant factors. How widely the information is published, that is irrelevant. A single copy of a book lying somewhere in some library is good enough to say that it is part of prior art. Single copy of document, single sale, that is sufficient. Actual disclosure is not important, potential disclosure is important. It is not that somebody actually had access to that information. Somebody could have access is also sufficient. So that is the extent of prior art against which you will be examining novelty of your invention. An invention that forms part of traditional knowledge is not patentable because traditional knowledge is part of prior art. There is another important point. In order to avoid double patent, in order to avoid double patent, that is, two patents must not be granted on similar invention. In order to avoid that, patent offices will include all the applications which have already been filed in the patent office before the date of filing of my application. So if I have filed application on 1st January 2024, all the applications which are pending in patent office, whether these are published applications or unpublished applications, or are included in the scope of prior art. And that is done to avoid double patenting. So this is the extent of prior art. I said prior art is defined in a very extensive manner. It is very broad. And therefore, it may be difficult for the inventor to prove novelty. There are certain informations which are excluded from the scope of prior art. We will not consider them to be part of prior art. Any information which has come to public domain because of breach of confidentiality shall not be considered as part of prior art. Now, this confidentiality can be an express confidentiality, it can be implied confidentiality. I wrote a paper, gave it to the publisher gave it to the reviewer, and reviewer is disclosing it to public. That is an information coming to public domain on the basis of breach of confidentiality. Although I may not have entered into a confidentiality agreement with the publisher, still it is a case of implied confidentiality. So law says any information which comes to public domain because of breach of confidentiality shall not be considered part of prior art. Point number 1. 2, there are situations where I have developed the prototype of my invention and I am exhibiting my prototype in one of the exhibitions notified by the central government. By virtue of section 31 subsection 1 of Patent Act 1970, any information which comes to public domain by way of this exhibition which is notified by central government shall not be considered part of prior art. But it will not be considered part of prior art only for 12 months. So within 12 months, if you file your application, this information which has come to public domain actually, because many people must have seen it in the exhibition, this information cannot be used to defeat the novelty claim of your invention. But if you file your application in the 13th month, This information can be used to defeat the novelty claim of your invention. These are some of the things which are excluded from the scope of prior art for determining novelty. I said something has been made available to public on the date of priority will constitute prior art. Anything which is made available to public on the date of filing of application will constitute prior art. What do we mean by that? Something which is made available to public. Something which is disclosed to public. What do we mean by that? The disclosure in the prior art has to be an enabling disclosure. The teaching in the prior art, the information in the prior art, in order to defeat the novelty claim of my invention, that information, that teaching, that disclosure has to be enabling. Enabling means it may enable a reasonably skilled man to work the invention. So, an enabling disclosure is one which enables a reasonably skilled man to work the invention. If you have such a disclosure, then your invention is not new. What I am trying to say, if the prior art, if you follow the information in prior art, it inevitably takes you to the invention, then your invention cannot be new. This is called inevitable result test. So, if the information in prior art inevitably always takes you to the invention is not new. But if the situation is that information in prior art may at times lead to the invention, then in that case your invention can be considered as new invention. Novelty here does not mean novelty of purpose, mind. We will talk more about it in our next lecture. What do we mean by novelty of purpose? Novelty of purpose means, for example, there is a drug called aspirin. When aspirin was invented, it was invented for a particular purpose. Later on, scientists discovered that aspirin is a very good blood thinning agent and can be used for that purpose also. They claimed a patent. Patent was denied. It is just novelty of use, nothing else. Later on, somebody again discovered that aspirin, if rubbed along the body, along the skin, it is a good insect repellent. Patent was denied on the ground that it is only novelty of use. There is an example, suppose there is a drug called X which reduces blood pressure. This is known. I am claiming patent on X for use as anti-diarrheal agent. The patent will be denied because I am claiming new use patent. So, novelty of use is not sufficient novelty under Indian law. So, we have understood that if invention is anticipated in prior art, it is not new. What is prior art? Very extensive. Any knowledge which is made available. What do we mean by that? Any knowledge which is made available means it must be an enabling disclosure. And we said novelty of use is not sufficient novelty. We also identified the things which have to be excluded from the scope of prior art. We said any information which comes to prior art by breach of confidentiality is to be excluded, which comes to prior art by exhibiting my prototype in an exhibition which is notified by central government is to be excluded. So, we understand the scope of prior art. There is one more limitation. The limitation is you cannot combine various prior art references to defeat the novelty claim of my invention. For example, suppose I have invented wheelchair, you cannot say that information about wheel is available in prior art and information about chair is available in the prior art. So, therefore, it is nothing but wheelchair. No, you cannot combine the two references to defeat the novelty claim. There has to be one reference in which the entire invention is to be anticipated. We have a case called as Raj Prakash versus Mangatram Chaudhary and others of 1977. Court says the invention has to be seen as a whole, and if the essential steps of the invention are novel, then the invention would be novel. In order to anticipate an invention, all elements of the invention must be present in a single prior art reference. You cannot combine various prior art references to defeat the novelty claim of my invention. I gave you that example of wheelchair. A wheelchair is not said to have been anticipated by locating wheel and chair in two different prior art references. So, this is another restriction on the scope of prior art. We said there are three limitations now. One, any information which has come to prior art by breach of confidentiality, that is not to be included. Two, by way of exhibition notified by central government, that is to be excluded. And three, a very significant limitation on the scope of prior art, and this is you cannot combine various references of prior art. Mosaicing is not allowed to defeat the novelty claim of my invention. So, that is about the first criteria, that is novelty. An invention has to be new, and in order to be called as a new invention, the invention must not be anticipated in the prior art, or you may call it state of the art. Prior art consists of entire knowledge pool which existed on the date of priority, and date of priority is the date of filing of application. Prior art has been defined in a very broad manner. So, therefore, as I said, there may be certain harsh results. So, in order to reduce harshness, I identified three limitations on the scope of prior art also. So, that is the first criteria, your invention has to be new. And new means absolutely new. It must not be similar to anything in the prior art. But keep in mind that you cannot combine various references of prior art to defeat the novelty claim of my invention. Now, coming to the second criteria, which is inventive step. Inventive step requires qualitative examination. If you recall, I said novelty requires qualitative difference, whether the invention is qualitatively different from the prior art or not. Whereas inventive step requires qualitative examination. In this factor, we examine whether the invention is sufficiently creative enough to grant patent or not. And therefore, it becomes a difficult task, because we are deciding creativity or inventiveness of that invention. We cannot adopt a comparative test. In novelty, we compare the invention with the prior art to decide whether it is new or not. In inventive step, we cannot adopt a comparative approach, because if the invention is creative, it is inherently creative, it is not creative with respect to other things. So, let us not adopt the comparative approach. Let us see how your act defines inventive step. It is there in section 2(1)(ja). Section 2(1)(ja) defines inventive step. It means a feature of an invention which involves technical advance as compared to existing knowledge. So, your invention must take us technically ahead of the prior art. It is technically an advanced version as compared to prior art. So, there is technical advance or having economic significance or both. So, therefore, if I can prove either technical advance or I can prove economic significance, any one of these will be sufficient. And that makes the invention not obvious to a person skilled in the art. So, there are two requirements. One, technical advance or economic significance or both. Two, the invention must not be obvious to a person who is skilled in the art. The invention must not be obvious to a person who is skilled in the art. We will have to understand all these terms. In many cases, inventive step and non-obviousness are used interchangeably. In many cases, patent offices examine non-obviousness, and if they come to the conclusion that invention is not obvious to a man who is skilled in the art, they will conclude that invention has got inventive step. Now, that is not the right approach, because there are two requirements and these are not alternative, these are cumulative. The first task is to see whether there is economic significance or technical advance. The second task is to see whether it is obvious or non-obvious to a man who is skilled in the art. I said determination of inventive step is a problematic area, because first reason is we cannot adopt comparative approach to determine whether it is sufficiently inventive or not, whether it is sufficiently creative or not. Second, it's a factual inquiry. It is a factual inquiry, and precedent is not going to help us, because every invention will be a new invention which comes to patent office. So therefore, what we did in relation to a similar invention, that thing will not come here, because you will never get a similar invention. So therefore, there is no value of precedents. And third, when you evaluate the quality in something, you adopt an evaluative approach. And if you adopt an evaluative approach, it is always possible that different people may come to different result. Yes, there may be differences. If I evaluate your answer script, the marks will be slightly different from the marks awarded by some other teacher. Evaluative method has this demerit. You cannot deny it. Because of these reasons, determination of inventive step is a difficult task. So let us sum up. Inventive step means two things. One, the invention in question must have technical advance or economic significance, or both. This is first. Second, it must not be obvious to a person who is skilled in the art. Mainly, the tests which we will discuss to determine inventive step is on obviousness or non-obviousness. And that is why I said that inventive step and non-obviousness are mostly used interchangeably. And if the patent offices are convinced that the invention is not obvious to a man who is skilled in the art, they will conclude that the invention has got inventive step. It is sufficiently inventive, patent may be granted. There is a test called as problem and solution approach. You identify the technical problem which is to be solved and identify the solution offered by the invention. And therefore, now, instead of asking whether the invention is obvious or not, the right question is to ask whether the solution offered by the invention to that particular technical problem is an obvious solution or not. This is called problem solution approach. We don't examine obviousness of the invention as such. Instead of asking whether the invention is obvious or non-obvious, what we will see whether the solution offered by the invention to the identified technical problem is an obvious solution to that problem or not. For example, if I have invented a pencil sharpener, or let's see what is the problem associated with pencil sharpeners. Let's take this simple example. When I sharpen my pencil, the shavings fall. When I sharpen my pencil, the shavings fall. In order to prevent those shavings from falling, I have attached a box in my pencil sharpener, and now when I am sharpening my pencil, the shavings are not falling, and I am claiming patent on my invention. The question will not be whether this invention is an obvious invention or not. Question will be whether the solution offered by the invention, what is the solution? Attaching a box. Whether the solution offered by this invention is an obvious solution to that technical problem. What was the technical problem? When you sharpen the pencil, shavings fall. This is problem solution approach. And there are two things here. We have been using the word person skilled in the art, person skilled in the art. We have been using this word. We need to understand who is that person who is skilled in the art. Because we are examining whether the invention is obvious or not from the standpoint of a person who is skilled in the art. We'll have to understand who is that person. Problem solution approach also includes an approach called as could-would approach. It also includes an approach called as could-would approach. I said the right question is not to ask whether the invention is obvious or not. The right question is to ask whether the solution offered by the invention is an obvious solution to the identified technical problem or not. This also includes another aspect, another question to be answered, which is related to could-would approach. It is not sufficient to say that the reasonably skilled person could have done it. I am providing a solution. I am providing a solution to the technical problem. Whether it is an obvious solution or a non-obvious solution, what will we do? We will ask a reasonably skilled man whether you can do the invention. If he can do it, if he can predict it, the invention is obvious. But the question is not only whether a reasonably skilled person could have done it, no, whether somebody would actually have done it. It could have been done by the reasonably skilled man, but nobody would have done it. Why? Because it was not a profit-making venture, maybe. Because prior art is full of information that this research is not going to succeed. Because the prior art is not inciting anybody to take up the task. And despite those discouragements in prior art, if the inventor took up the assignment and invented it, it is sufficient to be called as non-obvious. So we have to do two exercises. First is examine whether the solution offered by the invention to the identified technical problem is an obvious solution. And how will we do it? We will first of all see whether it could have been done by the person skilled in the art. And second important thing which we have to do, that it is not sufficient to say that person skilled in the art could have done it. We will also have to see whether somebody would actually have done it. Whether the prior art incites somebody to do this invention. We have another test called as windsurfing Pozzoli test. Windsurfing Pozzoli test. The relevant case is Windsurfing International Incorporated versus Tabor Marine, Great Britain Limited, 1985. Windsurfing Pozzoli test has 4 points. The first point is identify the skilled person. Who is the person skilled in the art? We'll have to identify it in all cases for each invention. So identify the person skilled in the art. Then you have to identify the inventive concept in the invention. Because if I have invented a machine, it is not that everything which I have presented before the patent office is owned by me. There will be some inventive concept inside that machine. So I am drawing heavily from public domain. I am drawing things from public domain and I am adding things from my side also to create a new thing. Now in that new thing, everything does not belong to me. What belongs to me is there in the part of the application which is called claims. Every patent application will have various parts. For example, you will have to write an abstract, 150 words. You will have to write a description part, describe the invention, describe it in such a manner that a reasonable person can perform it. It has to be an enabling disclosure. If you recall, I said patent is monopoly granted to the inventor, and in return what inventor does, he discloses his invention to the patent office. And towards the end of the patent application, the applicant, the inventor will write claims. What are those aspects of the description on which he is claiming monopoly? So on the basis of interpretation of those claims, we will be in a position to understand what is the inventive concept in the invention. So first is identify the skilled person, second is identify the inventive concept. How do we do that? On the basis of interpretation of claim. Then we'll have to identify the difference between prior art and the invention. The difference between prior art and the invention. And then finally ask this question to the person skilled in the art, whether the difference represents obvious steps. By exercising obvious steps, can the invention be reached? This is a test called as windsurfing-Pozzoli test. But as I have said, I have been using the word person skilled in the art. Who is that person who is skilled in the art? He is normally skilled means he has the knowledge about that subject. He has knowledge about that subject and he has knowledge about the related subjects. So, if the invention relates to physics, we will create a person who will have knowledge about physics and will have knowledge about related fields, maybe mathematics. But he will not have knowledge about absolutely unconnected field, keep in mind. Second, he is not imaginative. He is not imaginative by nature, because if he is imaginative by nature, he will predict any invention. If he is imaginative by nature, any invention will be obvious for him. He is not a real person. He is a legal creation. Patent office creates. So, the patent examiner will assume the role of a person skilled in the art. You must have studied in law of torts, reasonable man's test. A 12-year-old child hits a 13-year-old child in a situation where some festival is going on, and what the court will do? Court will say whether a reasonably prudent 12-year boy could have done it. Do they talk to a reasonably prudent 12-year boy? No. The court becomes a reasonably prudent 2-year boy. Same is the case here. A person skilled in the art is not a real person, it is a legal creation. Patent examiner assumes the role of a person who is skilled in the art. I already mentioned that the person skilled in the art has the entire background knowledge of the subject. He has read all the publicly available documents. He is deemed to have read all the information which is available in public. And he understands all the languages, so therefore he must have read all the books, French, German, whatever. He understands all the dialects. And he has no private preferences or dislikes. He cannot exclude some document, I don't like it. He cannot include some document, I like it. No, he will read every document. So, it is an imaginary construct, a notional construct in which we create a man who has the entire background knowledge, who knows about the subject, who knows about the subjects which are related to the core discipline. He is not imaginative by nature. He has looked at all the documents which are available in public domain. He knows all the languages, all the dialects. So, such an imaginary person is created, and this imaginary person will be asked questions whether the invention is obvious, whether the invention is non-obvious. In the test of windsurfing-Pozzoli, we said once you identify the inventive concept, identify the difference between prior art and inventive concept, then ask this man, do you think this gap can be filled by obvious steps? If he says yes, the invention is obvious. But there is an important point which we have to understand. We refer to the term prior art while examining novelty of the invention. We refer to the term prior art while examining novelty of the invention. In case of inventive step, it is closest prior art. The closest prior art will be different from prior art. We will not examine inventive step of an invention with respect to entire knowledge pool. No, we will examine inventive step with respect to a prior art which may be called as closest prior art. What does it mean? It only contains information about core discipline and related discipline. As I mentioned, a person skilled in the art will only know about that. The second very important difference is, I said in order to avoid double patent, all the pending patent applications in the patent office will be included in the prior art. In closest prior art, all the pending unpublished applications will not be included. So, unpublished pending applications will not constitute part of closest prior art. Why? Because it is unknown, unpublished, it is presumed to be imaginative content. As I said, my person skilled in the art is unimaginative by nature, so therefore he cannot possess any information which is imaginative by nature. So, barring these two differences, the extent of prior art and closest prior art are similar. So, if we have understood the difference between prior art and closest prior art, let me tell you again, the prior art which is used to examine novelty of the invention consists of every knowledge, including all the pending applications. The closest prior art will consist of that information which relates to the discipline, core discipline of the invention, and which relates to related discipline, because the person skilled in the art will know about only that subject. Second, the unpublished pending patent applications in patent office will not be part of closest prior art, will not be the information which is given to persons skilled in the art, because all these unpublished information are presumed to be unimaginative. So, that is the difference between prior art and closest prior art. Now, there is another difference. If you recall, I said mosaicing is not allowed in patent in examining novelty. We said that the entire invention has to be anticipated in single prior art reference. Wheelchair, if you remember, I said the entire invention wheelchair has to be anticipated in single prior art reference. You cannot say there is some information about wheels, there is some information about chairs. No, that is not allowed. But in case of examining inventive step, you can combine references from various prior art, because a reasonably skilled man is sufficiently competent to combine references. So, mosaicing is allowed while deciding inventive step. But what actually do we mean when we say that the invention is obvious or invention is not obvious? To decide whether the invention is obvious or not, let us see, we will have to decide obviousness from the standpoint of a reasonably expert man. The factor is, how will we decide? The extent to which the researcher has exercised choice or control in the inventive process. If there is no control exercised by researcher, it has happened on its own, it is obvious. If there is no chance of failure of that research, the invention is obvious. So, how will we decide whether it is obvious or not? We will see what is the extent of control exercised by researcher. In the absence of the control, the result would have been different. If the person skilled in the art, this is important, if the person skilled in the art can obtain the invention merely by logical analysis, inference, or limited experimentation on the basis of prior art, the invention is obvious. So, on the basis of prior art, after doing some logical analysis, limited experimentation, if a person skilled in the art can reach to the invention is obvious. Or there is a general rule, there is inventive step if the prior art leads the person skilled in the art away from the procedure proposed by the invention. If I follow the prior art, I reach to a result entirely different from the invention. That means it is not just following the prior art which has led to invention, there is some control exercised by the inventor. These are the statements which will help us in understanding as to what do we mean by an obvious invention. If the person skilled in the art can obtain the invention merely by logical analysis, inference, or limited experimentation on the basis of prior art, the invention is obvious. There is one more point to this discussion of inventive step. It is there in the case of Bishwanath Prasad Radheshyam versus Hindustan Metal Industries, 1982, Supreme Court. This is about two things. One is something known before or a combination of different matters. Court says in order to be patentable, an invention or something known before or a combination of different matters already known should be something more than a mere workshop improvement, and must independently satisfy the test of invention or inventive step. The improvement or the combination must produce a new result or a new article or a better or cheaper article than what already existed. So, we are talking about improvement improvement of something known before, or combination of two known integers, known things. Whether it is a case of improvement of something known before, or whether it is a case of combining two discrete things, the test as laid down in the case of Bishwanath Prasad Radheshyam case is to see whether this improvement or whether this combination is a workshop improvement or an invention. We will have to see whether it could be done by a mechanic or do you require a scientist to do it. If it could be done by a mechanic, then it is less than invention. For example, suppose there are doorknobs made of metals. During winters, you cannot touch those doorknobs because these become very cold. What I thought about porcelain, which is used in kitchen utensils, and I made doorknob using porcelain and clay. And I claimed patent on my invention. Court will say that changing the material is something which a mechanic could also do. You touch something which is cold, let us replace it by something which is not influenced by changing temperature. So this is only a workshop improvement. So any improvement or any combination of two discrete things will become patentable only once you prove that it is more than mere workshop improvement. The invention would have an inventive step if the combination of old known integers may be so combined, kindly see, if the combination of old known integers may be so combined that by their working interrelation they produce a new process or improved result. I said I have a pen, I attach a torch with that pen, I put on the torch and say that now my pen can write in the dark also. That is not an invention. If you are combining two integers, create an invention whereby their working interrelationship you produce a new result. For example, the light will glow the moment pen hits the surface. The light will glow the moment pen hits the page. Here the torch and the pen are working in an interrelated manner to produce a new result. That can be patentable. So therefore, one has to keep in mind that an improvement or a combination must be more than mere workshop improvement. Second, the interrelationship between the discrete parts which have been attached must produce a new result. So this is about the second criteria, that is inventive step. Coming to the third criteria, which is industrial applicability. Patent protection should not be available for purely abstract creation. There is no use in granting patent to inventions which are of no use. So therefore, abstract creations will not be granted patent. The invention must be concrete, must be of technical character. This industrial applicability criteria is very important in relation to biological inventions. It is very important in relation to method of medical and veterinary treatment. You invent any method of treatment of humans and animals, that will not be granted patent because we consider that method of treatment lacks industrial applicability. So the criteria of industrial applicability has ensured that method of treatment of humans and animals are not granted patent. I said it is an important criteria in relation to biological inventions. I will talk more about that. So this is the third criteria, which is that only concrete inventions which are of technical character, only those inventions will be granted patent protection, and purely abstract creations will not be granted patent protection. Capable of industrial application may mean two things. Capable of industrial application may mean that it can be used in industry or it can be made in any kind of industry. So industrial applicability does not mean it is useful in industry. It can be either used in industry or if it is manufactured by industrial process, even then the requirement of industrial applicability is satisfied. And the word industry is to be understood in a very broad sense. It includes even agriculture. So therefore, in every invention, in order to claim patent, you will have to show that the invention has a useful purpose. I said it is important in relation to biological research. Isolation of a gene sequence must deliver a new state of affairs of practical utility to humanity, not simply the discovery that a certain nucleotide sequence exists in nature. You must have read about Human Genome Project. We are in a position to understand the entire gene makeup of human body, but the entire project will be denied patent because unless we identify the use of different genes which we have identified, it is not fit to be granted patent. So, this mere discovery that certain nucleotides exist in nature will not be sufficient to claim patent. You will have to tell as to how those genes will have practical utility to humanity. So, therefore, in relation to every newly identified or isolated gene sequence, in order to claim patent, you must clearly identify the practical utility of that gene sequence, which in many cases is difficult. Therefore, I said in biological inventions, good number of inventions fail to get patent because they fail to prove the requirement of utility, industrial applicability. So, any isolated gene sequence which is identified or isolated, unless you tell as to what is the practical utility, no patent shall be granted. In the 19th century, beriberi was a major cause of death. This disease caused many deaths. There was a scientist, Suzuki, who discovered a substance in rice bran, thiamine or vitamin B1. This was the first vitamin to be isolated. In 1911, he got Japanese patent. Now, the point which I want to highlight here is, what he extracted was only a natural thing. So, he was granted patent on vitamin B1, which is nothing but a natural thing. So, can you claim patent on something which existed in nature? A similar example is the case of adrenaline. Adrenaline was extracted from human tissues, from animal tissues, and this was extracted for therapeutic use. The inventor Takamine claimed patent, and the judge of the American court, Judge Learned Hand, he allowed patent on adrenaline extracted from animal gland tissues, although it is part of nature, it existed in nature. Why he granted patent, or why patent was granted on vitamin B1? The basis is, he says that although adrenaline were merely an extracted product without change, there is no change, it is extracted from gland tissues, it became for every practical purpose a new thing, commercially and therapeutically. Now, it has become a new thing commercially and therapeutically means what? There is a utility, there is an applicability. It is useful both in commercial sense as well as in therapeutic sense. And it is the inventor who made this naturally occurring substance available to be used for therapy and commerce. So, that is how utility can be a factor to claim patent on discoveries or isolation of naturally occurring substances. It is an important criteria. Rule number 27 1F of European Patent Convention requires the inventor to indicate explicitly the way in which invention is capable of exploitation in industry, how it is going to be used in industry. The biotech directive also requires that the inventor must specify which protein or part of a protein is produced and what function it performs. So, industrial applicability or utility is an important criteria. Now, let us sum up the meaning of industrial applicability. It means first, invention must belong to an industrial field. It must not be an abstract thing. Second, it should be capable of being actually made in the sense that it is feasible. Somebody must actually make it. It will not be sufficient to prove that in future somebody may make it. No. You have to prove that there is a clear benefit and somebody will actually make it in the sense that it is feasible. And third, some immediate concrete benefit can be derived from the claimed subject matter. This is what we mean by industrial applicability. So, in the present session, we discussed the three criteria of patentability. The invention, in order to get patent, must pass the requirement of novelty, inventive step and industrial applicability. I said for novelty we can adopt a comparative approach, but for inventive step we need to examine whether the invention is sufficiently creative, sufficiently inventive. That is a difficult thing. We also discussed that utility or industrial applicability is an important criteria, at least in case of biological subject matter. There are three parts in patent law: patent prosecution and patent litigation. We have discussed the criteria in this session. Next session will be on patent eligibility. These criteria were patentability. Patentability will be examined, but first of all, when an invention comes to patent office, the patent office has to see whether it consists of subject matter which is fit to be granted patent, that is patent eligibility, which we have in section 3. Once we understand section 3, then we will go to patent prosecution. So, next lecture will be on patent eligibility, that is section 3 of the Patent Act. Thank you very much for joining this session. Thank you once again, and we will meet for our discussion on section 3 in the next session. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.